Hello friends, today I am discussing theories of jurisprudence, theories of justice in jurisprudence. Justice is the soul of law. Jurisprudence, as the philosophy of law, offers a kaleidoscope of the theories that attempt to define what justice truly means. These theories are not mere academic exercises, they shape constitutions, influence courtrooms, and inspire revolutions. Now, first theory is Aristotle teleological theory. Aristotle's teleological theory of jurisprudence says that law and justice should be understood by their purpose. That is the aim of helping people live good and virtuous lives. Justice means giving people what they deserve based on their abilities and contributions, not treating everyone the same. The goal of law is to support individuals and society in reaching their highest potential and flourishing. Aristotle justice is not about giving everyone the same thing, but about giving each person what they deserve in order to create a good and fair society. So, when making laws or judging cases, we should always ask what is the purpose of this law and does it help people live a more virtuous life? In summary, Aristotle's teleological approach ties law and justice directly to the purpose of human flourishing and the achievement of the good life. Second is Jeremy Bentham's utilitarian theory. The utilitarian theory of jurisprudence holds that laws and judicial decisions are right if they promote the greatest happiness for the greatest number. It judges legality or by the outcome's utility, focusing on maximizing overall social welfare and minimizing harm. Developed by thinkers like Jeremy Bentham and John Stuart Mill, this theory views the purpose of law as achieving the maximum good for society as a whole, making justice essentially about usefulness and happiness. In short, we can say law should serve the greatest good of the greatest number in an impartial and practical manner. Rawlsian theory of justice. John Rawls' theory of justice states that a just society is one where individuals agree on principles of fairness from an original position of equality behind a veil of ignorance about their social status. It guarantees equal basic liberties for all and permits social and economic inequalities only if they benefit the least advantaged members of the society. This ensures a just legal system grounded in equality, fairness, and protecting the vulnerable, rejecting selfish bias and utilitarian sacrifice of minorities. It is a powerful framework for law based on moral equality and social cooperation for all. Now, fourth is Robert Nozick, libertarian theory. Robert Nozick's libertarian theory of justice insists that justice lies in the rightful ownership and voluntary transfers without enforced redistribution. Any wealth distribution is just if acquired legitimately, and the state interference beyond protecting individual property rights is unjust. This theory champions absolute personal liberty and minimal state power, condemning forced wealth redistribution as theft. Precedent. What is precedent? Precedent, it is a major source of law. In jurisprudence, precedent is recognized as one of the major sources of law, particularly in common law systems like India, England, and the United States. It refers to the judicial decision of higher courts that serve as authoritative rules for deciding future cases involving similar fact or legal issues. A precedent is a previous judicial decision that serves as a rule or guide for future cases. According to Keaton, a judicial precedent is a judicial decision to which authority in some measure has been attached. Salmon explains that the common law of England largely developed through judicial precedents rather than legislation. Legal basis and doctrine. The doctrine of precedent rests on the principle of stare decisis, meaning to stand by decided cases. Under Article 141 of the Indian Constitution, the law declared by the Supreme Court is binding on all courts within India. This ensures consistency, stability, and predictability in legal interpretation. Now, what are the types of precedents? So, the following are the types of precedent. Number one, binding precedent must be followed by lower courts when the higher court decision covers similar material facts. Persuasive precedent, not binding but may influence a court decision, for instance, English or other high court rulings. Declaratory precedent applies an existing legal rule. Original precedent establishes a new legal rule contributing to judge-made law. Absolutely and conditionally authoritative precedent, respectively binding in all cases or may be disregarded under special conditions, such as being overruled or per incurium decided in ignorance of a statute. Advantages of precedent. Precedent ensures certainty, equality, and efficiency in the legal system. Because similar cases receive similar treatment, public confidence in justice is strengthened. It saves judicial time and develops law in harmony with social evolution. Disadvantage. Some of their disadvantages also. The system can become rigid as inferior courts may feel bound by outdated rulings. Complexities in identifying the ratio decidendi, legal principle of the case, and distinguishing it from obiter dicta, non-binding observation, also pose interpretative challenges. So, conclusion. Judicial precedent is a vital and dynamic source of law that provides uniformity while enabling gradual legal evolution through judicial creativity and interpretation. It strengthens evidence of the close connection between judicial reasoning and legal development in jurisprudence. Now I am coming to what is Roscoe Pound's theory of social engineering. It says that law is like engineering for the society. Just as engineers build structures to work well, the law helps balance pe- different people's interests to create harmony and reduce conflicts. Its goal is to satisfy as many people as possible with the least conflict. The law should change and adapt to society's needs, guiding behavior to make society better and fair. One short example of social engineering in law is reservation policies in India. These laws balance the interests of marginalized communities by reserving seats in education and government jobs for them, while also considering the overall social harmony. This is a practical use of law to engineer society by addressing historical inequalities and promoting social justice. Now I'm going to tell you what are the rights of an unborn child in jurisprudence. They are recognized as conditional or potential rights based on the necessitous rule. That means that a child once conceived may be treated as born for legal benefits, provided it is born alive. Here, necessitous is a Latin term meaning one who is to be born. Now, what are the key points? The unborn child is not a full legal person, but a judicial person, protected from specific purposes such as inheritance, property, and life. Rights include right to life, inheritance, compensation, and medical care. Second is Transfer of Property Act 1882, Section 13 and 20. According to this, allows property transfer of the benefit of an unborn child, provided the child is born. Hindu Succession Act 1950 says, grants the unborn equal rights in inheritance as if they were already born. Bharatiya Nagrik Suraksha Samhita under Section 472 says, postpones or commutes the death sentence for a pregnant woman, recognizing the fetus life. Limitation Act 1963, Section 6 extends legal disability protections to unborn children in certain contexts. Now there is a case law in MC Chokalingam versus Union of India 1982, Baby Manji Yamada versus Union of India 2008 have upheld the unborn's legal protection. So, jurisprudentially, protection begins at conception, while full legal personality begins at birth, balancing maternal rights and fetal welfare. Thanks for watching this video, friends. Do subscribe this channel.